House is resumed. Mr Chairman.
Mr Speaker, the committee has considered the Residential Tenancies Amendment Bill and reports it with amendment. Mr Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. This bill is set down for third reading forthwith. Honourable Phil Heatley.
Mr Speaker, I move that the Residential Tenancies Amendment Bill be now read a third time. This bill amends the Residential Tenancy Act 1986. I introduced this bill to the House on 13th of May 2009 and now pleased to begin the bill's final process for passage through the chamber. Now, keeping the Kiwi dream of home ownership within reach is a key focus for this government, as many will know, and that's why we're working so hard to make housing more affordable by freeing up the supply of land and reducing the red tape that's been strangling the building and construction sector. And I'd like to acknowledge my colleagues, the Honourable Morris Williamson and the Honourable Nick Smith, who are working hard on the Resource Management Act and the Building Act in order to streamline them to make sure that that red tape is indeed slashed. We're also easing the burden of interest rates by growing the economy. We don't want to see the interest rates go to 8-9%, 10% like they were under the previous government, so that people can afford a mortgage. And we're eliminating low-quality spending and progressing a program of personal tax cuts so people can better afford a mortgage. But the reality is there will always be those who rent for either lifestyle or affordability reasons, want or need to rent a place to live. And since the vast majority of families rent privately, it's important to ensure that the legislation governing the sector supports adequate private sector provision of decent rental housing. And that's why this legislation, Mr Speaker, is all about balance. It'll enable the thousands of mum and dad landlords throughout the country to manage their tenancies and protect their investments, while ensuring that those people who rent their homes have access to stable, good quality housing and also the protections that we would expect that they would be afforded. The bill extends coverage of the Act to more people involved in renting, including those being the most vulnerable tenants in New Zealand, ones living in boarding houses. Up until this Act is passed, those living in boarding houses did not have significant protections, but protections are there now. For example, the one that I spoke about during the committee stages, where boarding house operators will now need to give 28 days notice for someone to move on instead of just 24 hours. We're going to clarify the responsibilities for outgoings such as water rates by introducing overarching principles to indicate where landlords or tenants are responsible for charges. Introduce clearer and fairer processes for terminating and renewing tenancies to provide an appropriate balance between flexibility and certainty of tenure, and encourage landlords and tenants to comply with the obligations, for example, by enabling the Tenancy Tribunal to award financial penalties against landlords who don't live up to their side of the bargain, and improving the enforceability of Tenancy Tribunal orders. Just as important as what the bill amends are those features of the Act that have served us well over the years which the bill retains. When things go wrong, it's important that both landlords and tenants can access quick, low-cost and impartial dispute resolution services. And that is why this government's very reluctant to open up the Tenancy Tribunal so freely to lawyers, as the Labor Party would suggest that we should. The dispute resolution process under this Act is an extremely exemplary example of how this can be achieved, where those, as I said, particularly in the tenant situation, if there's a David and Goliath situation, if it's a minor, if it's someone with a disability, if we're talking about large sums of money, over $6,000, or a situation where a landlord has themselves a lawyer or an advocate, in all those cases a tenant can access advocacy and in many cases legal counsel. Tenancy adjudicators have specialist knowledge of the Act and are empowered to make an inquisitorial approach to resolving disputes, which is quite different from the court system, and another reason why we don't need lawyers to freely enter the dispute resolution process when it comes to the tenancy tribunal. Landlords and tenants are encouraged to represent themselves at hearings with the use of solicitors and representatives limited to only, as I said, listed where the nature of disputes brings particular disparity between the parties. And this means the process is quick, cost-effective and, most importantly, very, very fair. Mr Speaker, during the consideration of the bill, the Social Services Select Committee heard from a wide range of submitters with a diverse range of backgrounds and perspective. This is testament to the fact that our tenancy laws affect people from all walks of life and political persuasions. Tenancy laws will always contain contentious elements. Strengthening the rights of one party almost inevitably means reducing the rights of another, and this legislation here seeks to balance things out more perfectly than has been in the past. I'd like to again acknowledge the difficult and important role that the Social Services Select Committee has played in ensuring that these competing interests were properly considered and appropriately balanced in the bill. I'd like to acknowledge the work undertaken by the previous government in terms of what we've passed or proposing to pass here today. I'd also like to acknowledge the work of the opposition in investigating and putting forward supplementary order papers or amendments which were actually substantial, thought out, and that attempted to address issues that were real. There was no trifling with the health. The amendments put forward were worthy of consideration. Obviously, we chose to vote against them for good reasons of our own, but we appreciate the debate. I'd also like to thank the Select Committee staff, Department of Building and Housing officials and the PCO drafters who worked on the bill. Most importantly, I'd like to thank the hundreds of landlords, tenants and others with an interest in tenancy matters who participated in the review of the Act and, by sharing their experiences, helped shape a better bill. Mr Speaker, the reform of the Act, which directly affects the lives of around 1/3 of New Zealand households, has been a long time coming. I acknowledge that. It is with pleasure and satisfaction that I am able to oversee its final progress through the House. I commend this bill to the House.
The question is that the motion be agreed to. Moana Maki.
Thank you, Mr Speaker.